name is Susan Posner, and I'm the Provost and Vice Chancellor for Academic Affairs at the University of Illinois at Chicago. We are delighted to co-host this forum along with Injustice Watch and the Chicago Lawyers Chapter of the American Constitution Society. I want to thank Juliet Sorenson, the Executive Director of Injustice Watch, and David Shapiro for bringing this opportunity to our attention, and Darby Dickerson, the Dean of UIC John Marshall Law School, for offering to host this here at UIC. As you hopefully all know, this law school became the 16th college at UIC just last August. After 3 years of discussion and negotiation and planning, this finally came to be. By bringing John Marshall into the largest university in Chicago and Chicago's only public research university, we have created Chicago's only public law school, and opportunities to take advantage of our overlapping missions of academic excellence, service, and diversity, to expand curricular opportunities for law students, and to bring the benefits and influence of legal training to UIC's undergraduate and graduate students by growing interdisciplinary programs. That's the mission and the plan, the vision for this law school. We're actively doing all of this already, creating programs that bring together the law and the health sciences, exploring ties between intellectual property law, which is already a great strength of the law school, and our innovation center at UIC, and looking for ways that we can embed UIC graduate students working in areas like social work, psychology, and social justice in the law school's community legal clinics, thus providing an opportunity for one-stop shopping in a multidisciplinary practice setting for clients who come to the law school clinics seeking assistance with issues that involve, for example, domestic violence, evictions, veterans claims, and juvenile justice. And this is just the tip of the iceberg of exciting things that are happening as a result of this merger. But yet another reason that UIC is thrilled to have a law school is because it provides public service opportunities in the law, like the one we have this evening, and to be engaged in the important upcoming 1st District Illinois Supreme Court election. So to talk a little bit more about that and get the program going, it's now my pleasure to introduce Darby Dickerson, Dean of the UIC John Marshall Law School. Thank you.
Good evening, everyone. I want to echo Provost Posner's thanks to Injustice Watch and the American Constitution Society for affording UIC John Marshall the opportunity to co-host this very important event. We are very proud to be Chicago's public law school. We have about 1,100 students, 53 members of the full-time faculty, about 150 adjuncts who are primarily practicing attorneys and members of the bar. And we serve students by educating them in our JD program, our LLM program, and our Master of Jurisprudence program. And one thing that is a great reason we're hosting this tonight is UIC John Marshall has produced historically, even though we're relatively new to UIC, we're 120 years old, more judges for the state of Illinois than any other Illinois law school. So we continue to be committed to that, to train people to enter public service and government service. And we do this in a variety of ways, our curriculum, but really importantly, the 9 legal clinics that we have here in the building to train students to become outstanding lawyers and leaders. Our law school was named after Chief Justice John Marshall, who cemented the concept of judicial review and the importance of the judicial branch on the federal level. The judicial branch upholds the rule of law, which is a pillar of our democracy. So to demystify the work and role of the judiciary is critical. And for this reason, I want to thank all of the candidates for participating with us tonight. I again want to thank Injustice Watch and the American Constitution Society for putting on this forum. And I want to thank all of you for participating and upholding our civic duty to go out and to vote. So thank you very much. And with that, I'll turn the program over to your moderators, Juliet Sorenson and David Shapiro.
Thank you so much, Provost Posner, Dean Dickerson. Welcome, everyone. I'll briefly introduce the candidates. My colleague David Shapiro will lay out the process and procedure for the evening. And as I say, the introductions will be very brief because each candidate has the opportunity to make an opening statement, and you will hear from them next. Immediately to my left, the Honorable Cynthia Cobbs, Justice of the Illinois Appellate Court. To her left, the Honorable Scott Neville, appointed to the Illinois Supreme Court in 2018. To his left, Mr. Daniel Epstein. To Mr. Epstein's left, the Honorable Jesse Reyes of the Illinois Appellate Court. To Justice Reyes's left, the Honorable Nathaniel Howes of the Illinois Appellate Court. And finally, on my far left, the Honorable Margaret Mcbride of the Illinois Appellate Court. As I said, I'll leave the bulk of the introductions to the candidates themselves. David?
Thank you, Juliet. The first portion of the program will be 2-minute and 30-second introductions by the candidate. Then we'll go to a period of moderator-asked questions. Once the question is asked, the candidate has 2 minutes to answer the question. And the timekeeper, situated over there, will aid the candidates as to the time left by holding up signs indicating 30 seconds, 15 seconds, 5 seconds, and stop. We're going to enforce the limits strictly. And please do speak into the microphone so that your voice is picked up. Audience members are going to be invited to submit questions on the index cards that will be gathered by the student volunteers who are from the John Marshall UIC Dean's Leadership Academy. If you do submit a question, please note the particular candidate to which your question is addressed. And with that, we'll begin opening statements.
Okay, so for opening statements, we'll proceed from my far left to my near right. Justice Mcbride.
Good afternoon, everyone. Can you hear me? All the way in the back?
Yes.
So we were asked to give a 2-minute introduction. My name again is Margaret Stanton Mcbride. I sit on the Illinois Appellate Court. I've served there for 20 years. Before that, I was on the Circuit Court of Cook County for about 12 years. Before that, I was an associate judge. I was an elected circuit judge in 1990. And I served as an associate judge before that. Prior to that, I spent 11 years as a lawyer, first with a small civil firm and then with the Cook County State's Attorney's Office. In the Circuit Court of Cook County, I have served in 5 major divisions of the court. I began in the first municipal, then I was assigned to the criminal division, then I spent time in the law division, then I spent time in the prestigious Chancery Division, and then I became the presiding judge of the Rolling Meadows Courthouse, where I supervised 20 judges, 20 courtrooms, a large administrative staff. I've been on the appellate court for 20 years. I was elected in 1998. I've written about 2,000 decisions by way of opinions, Rule 23s, and what we call summary orders. That's primarily my background. I am running for the Supreme Court on that old-fashioned idea that qualifications matter. That's what I'm running on. I have experience in the criminal law that none of the other candidates have. I have experience in the law division that none of the other candidates have. I have administrative experience, having been a supervisor in the State's Attorney's Office and having been a presiding judge. I have actually served in every administrative capacity at the Illinois Appellate Court. I've written on more issues than anyone here, and I have actually been in the trenches for 12 years, hearing and trying thousands of criminal and civil cases. I've heard witnesses, I've heard lawyers, I've heard litigants, and all of my decisions, I'm proud to say, have been fair and impartial. My reputation for being fair, impartial, hardworking, diligent, honest, and all the good things you want in a judge have followed me for 32 years. Thank you.
Thank you, Justice McBride. Justice Howes.
Good evening, ladies and gentlemen. My name is Nathaniel Roosevelt House. I'm a judge on the Illinois Appellate Court and, of course, a candidate for the Illinois Supreme Court. I want to discuss my perspective and my background, because I think that's very important when you consider Supreme Court judge. The Supreme Court considers a lot of important decisions, and many times those decisions depend on how the judge sees things. So I think the judge's perspective is important. I believe in fairness. I believe in justice for people of all races, ethnicities, religions, and backgrounds. I believe in justice for the underdog. I believe in justice for the underdog because I was born an underdog. I was born in Murfreesboro, Tennessee, under the vestiges of the Jim Crow laws. I attended segregated schools, went to segregated movie theaters. My father moved the family to Chicago when I was a child to seek better opportunities. This gave me a particular perspective on what it meant to be an underdog and how the unequal treatment of justice affects people. My father, when we got to Chicago, my father worked full-time, but he also decided he wanted to be a lawyer and went to John Marshall Law School at night to become a lawyer. I remember him leaving early in the day and getting home late from work after going to class. I remember on the weekends, my brother and I, we would sit at the kitchen table doing our homework. And we could look into the dining room and see my father doing his law book work. And I became a lawyer, followed in his footsteps. For 22 years, I practiced law. During that time, I represented thousands of clients in complex cases. I represented the Harold Washington Party. I represented the Justice Party. I believe that I'm the only candidate who's running who actually argued a case before the Illinois Supreme Court. For more than 10 years, I served as a judge on the Circuit Court of Cook County, and for more than 10 years, I've effectively and efficiently served on the appellate court. For example, every judge on the appellate court is given the same amount of work, and at the end of each quarter, there's a survey taken of how many cases are on the docket that are undone. For the last 4 years, I've led the court by having 0 cases undone. I passed the rule as the chair of the executive committee, requiring any judge who had a case over 6 months old who has not written a decision for it to write an explanation. As a consequence of holding my colleagues accountable, the number of cases over 6 months has diminished under my administration. The perspective is important because those difficult decisions, and I believe also that a Supreme Court judge should be above reproach. Remember, house is in the house.
Good evening, everyone. My name is Jesse Reyes, and I am currently on the Illinois Appellate Court. And I first want to thank our sponsors and our hosts and all of you in attendance for being here. But particularly, I want to take a personal privilege in acknowledging the hosts. John Marshall Law School has been known as the School of Opportunity. And growing up on the South Side, there was some doubt whether I'd ever even gotten in the neighborhood to get to where I'm at today. But John Marshall was responsible for giving me that opportunity, and I welcome that. And that's one of the reasons why I'm running for the Illinois Supreme Court, because of the opportunity a school like John Marshall provided me to get a legal education. I'm the son of immigrants. I come from a working class neighborhood, working class family. I grew up on the South Side, as I mentioned before, and one of the things that I made a determination to do when I got out was to give back. And I felt the only way and the most important way to be able to give back is through public service. And one of the most notable and honorable ways of giving back through public service is serving as a judge. And that's why I decided to become a judge of the Circuit Court of Cook County. I started out as an associate judge, I became a Circuit Court judge, and now I'm currently on the appellate court. And each time that I've run for those positions, I've either been found highly qualified, or recommended by the bar associations. When I first got on the job, the first day I went to the chief judge and I said, if anybody gets sick, goes on vacation, dies or retires, and you need anybody to fill in the spot, I'm your person. And they took me up on it. And for the first few years while I was an associate judge, I traveled around the entire county, seeing a variety of different assignments, hearing a lot of different types of cases. And I enjoyed that experience because it provided me an insight into what I do now on the appellate court. It gives me an insight what happens in the trial rooms on a daily basis. But, you know, I believe also in serving the public off the bench. And I've been committed to giving back to the communities. I've been committed in terms of developing a foundation called the Diversity Scholarship Foundation to give back to young people. And we have given out scholarships to people throughout the state. 90% of our recipients actually have been women. 50% of the recipients that have received scholarships through the Diversity Scholarship Foundation have been African American. We give out scholarships to a variety of other different types of students. But just briefly, because my time is running out, That's who I am. I am a person who makes sure that I give back to the community, that I solve problems when I see them in our justice system, and that's what you'll get when you vote for 161 on Election Day. Thank you very much.
May I remind the candidates to lean into the microphone, please?
Okay.
Thank you.
Yeah.
Yes, I'm sorry, Mr. Epstein, go ahead.
I'm Daniel Epstein. I'm an attorney, and my grandfather graduated from John Marshall back when Dean Noble Lee worked here, and he collected tuition by walking the halls and accepting change in one of those change machines that waiters and waitresses used to have. I'm not a John Marshall grad. I'm a University of Chicago law grad, but interestingly, I looked up some of the stats. You all have 13 judges on our courts of review out of the 62. University of Chicago, unfortunately, has 0. So you guys are doing well there. We're going to try and add one. But I'm an attorney. I worked for the #1 law firm for pro bono service in the country, Jenner and Block, where I did a lot of pro bono work, so much so that they either had to fire me or give me a trophy, and luckily they chose the latter, but it was close. I won their pro bono award for serving the needy. I chaired the Chicago Bar Association Committee on Alternative Dispute Resolution. I co-authored the Illinois Civil Practice Guide that some use to teach civil practice to their students. I built an online court of arbitration. But I'm not running because of a resume. I'm running for reform, because the Illinois Supreme Court doesn't just decide cases, it also writes rules. The Illinois Supreme Court rules of procedure, rules of evidence, rules of ethics. They determine design standards of courthouses that have an impact on access to justice for undocumented people and trans people and people with disabilities and people with caretaker responsibilities and people with jobs. They have a role to play in the data and technological infrastructure of the courts. They have a role to play in attorney discipline, in determining who gets to be a lawyer and how, and on and on and on. They're not just case deciders, they're policymakers. And we are in deep, deep need of reform in that regard. The fairest judge can't achieve justice in an unfair system. It's incumbent upon us to ensure that the system itself is fair. That's what the rules do. That's what they can do. I'm trying to reform rules of procedure to expand criminal discovery so that we don't fall prey to 20 years of police misconduct, the kind that John Burge perpetrated. I'm trying to reform Illinois rules of evidence to make it so that junk science can't make it into our courts, to wrongfully convict people like the ones that I represented. I'm trying to reform our code of ethics to make it so that we don't have to wonder whether there are conflicts of interest that our judges are confronting. My name is Daniel Epstein, and I'm running up for reform.
Justice Neville.
Good evening. I want to thank UIC and John Marshall for hosting this forum. My name is P. Scott Neville Jr., and I am on the Illinois Supreme Court. I think there are a few things that the voters should look at when they consider who is going to remain on the Illinois Supreme Court. First of all, I would suggest that you look at this little card. It provides a lot of information. I have 45 years of legal and judicial experience. When you consider the fact that the Illinois Supreme Court could have elevated any of my colleagues on the appellate court to the Supreme Court, you should pay very close attention to the fact that they appointed me. The bar associations, my colleague, former colleague, Justice Mcbride, pointed out that ratings matter. I agree with her. If you pay attention to my ratings, you will discover that 5 bar associations found me highly qualified for the Illinois Supreme Court. Another consideration might be, what did the Democratic Party do? All of these candidates submitted their credentials to the Democratic Party, but the Democratic Party selected me as their standard bearer. But it's not only my 45 years of experience, not my 5 highly qualified bar ratings, but it is my body of work. My body of work will reveal that I have reversed more cases than any judge sitting on this, or sitting up here with me this afternoon. The Supreme Court elevated me because they know I am going to bring substantive change. My body of work also reflects that I am on a mission to make things better in Cook County. Martin Luther King said the moral arc of the universe bends towards justice. My moral arc also bends towards justice and is guided by the due process and equal protection provisions of the 14th Amendment. I'm the equal justice for all candidate, and I'd ask you very seriously to consider me. I would like to thank once again UIC and the John Marshall Law School. I think this is a wonderful, wonderful forum, and I'm looking forward to your questions.
Last but not least, Justice Cobbs.
Thank you very much. Good evening, everybody. I am Justice Cynthia Cobbs. I'm a justice on the Illinois Appellate Court. And I would start by echoing the sentiments of those who joined me here on the dais by thanking the three principal hosts for hosting this event this evening. I'm truly privileged and honored to be amongst you and to share my credentials. My trajectory to the appellate court is quite different from my colleagues who sit on the appellate court. I've been an attorney since 1988, and yes, I attended the law school that had been perceived as the rival to John Marshall. I graduated from Chicago-Kent College of Law. But nonetheless, my mentor, Justice Charles E. Freeman, graduated John Marshall, so I have a space in my heart for this school as well. I started my professional career in the state of Maryland. I went to a historically black college, Morgan State College, and I attained my master's in clinical social work from the University of Maryland. It was that degree in social work and working with abused and neglected children that brought me into the courts in Maryland. In those courts, I advocated for the protections of children. I often encountered judges and lawyers who were either GALs or individuals who were representing parents. I found while in those courtrooms that perhaps the best way to advocate for those children was to receive a law degree. So in 1983, I moved here to Illinois, and I did attend Chicago-Kent and attained that degree. I have been in the Illinois court system for 31 years. Like most law students graduating law school, I applied to probably every law firm that was available. Unfortunately, although I was perceived to be a solid law student, I had deans listed enough times, I received more rejection letters than I'm able to count. The one rejection letter that I didn't receive was from the First District Appellate Court. And after serving on the appellate court in the research division for 6 months, I was invited by Charles Freeman, Justice Charles Freeman, to serve as his judicial law clerk in the appellate court. Little did I know he was seeking a seat on the Supreme Court, where he invited me to serve as a Supreme Court judicial law clerk. From my clerkship, I went to the court's administrative office to serve as part of the administrative arm of the court. In 2002, that same Supreme Court appointed me to serve as the director of the Illinois courts, overseeing all of the work of the courts. I've clerked on the appellate court, I've clerked on the Supreme Court, I've administered the court system. I believe that I am uniquely qualified to serve as a justice on the Illinois Supreme Court. I can't say it all. www.justicecobbs.org is my website. I invite you to visit there, and you can read for longer than 2.5 minutes. www.justicecobbs.org. Thank you.
Thank you. We now turn to questions posed to the individual candidates by the moderators. Justice Neville, you're up first. As you mentioned, you have received the endorsement of the Cook County Democratic Party in the primary. Last I checked, judges are not in the business of party politics. Why, in your view, does this endorsement matter at all in an election for Illinois Supreme Court Justice?
Because for reasons beyond me, this has been the custom and tradition of running for political office in this county and in this state. Note that all the people sitting up here also sought that endorsement. It is simply the way things have been done since before I became a lawyer, now that I've been a lawyer, and since I've become a judge. I think the party's endorsement matters, and that's why I sought it.
Related question for Justice McBride. Do you believe that endorsements, which may create the appearance of future conflicts of interest, are bad for judicial campaigns?
Well, first of all, I do want to correct something that Justice Neville said. I appeared before the slate makers and I asked for an open primary. I did not seek their endorsement. And could you ask the second question about the significance? Would you be so kind?
Yes, of course. Do you believe that endorsements, which may create the appearance of future conflicts of interest, are bad for judicial campaigns?
I don't think that we can debate the issue of slating, electing our judges for the benefits of merit selection. I will say that I have never been traditionally one of the boys. I ran in 1990 for the Circuit Court of Cook County. I had the highest bar ratings of any candidate that ran. I had a newspaper endorsement, the Sun-Times. I was successful in my election to the Circuit Court without the slating and support of the Democratic Party. Would I have perhaps liked that endorsement back at that time? I suppose, but I did not receive it. A man did. Then I ran in 1998 for the Illinois Appellate Court, after having served, mind you, for 12 years in numerous divisions of the Circuit Court that I've already talked about. At that time, once again, I was not the slated candidate. However, I did have the highest bar ratings of the 10 of us that were running, 7 sitting judges. And of the 10, I received both newspapers, they both endorsed me, and I was the successful Democratic candidate. So in my opinion, and as I say, I suggested an open primary in this race because of the wonderful, diverse group of people that are running. You're hearing us all today.
May I respond to a comment that Justice Mcbride made?
Very briefly.
She indicated that I needed to be corrected so that the record is set straight. Be advised I was not in the room when she commented, and the only reason I can see you appearing for slating is to be slated. So I don't know what she did or what she said, but I simply assumed since she was there, she was seeking the slating of the party.
Moving on. Mr. Epstein, you're the only candidate here tonight who has not served as a judge. In other words, you haven't ruled on cases, issued opinions, held oral arguments, or weighed in on matters of the administration of the courts. What, in your view, makes you the best candidate here tonight?
Yeah, so also other people who fall into that category before they joined the Supreme Court include Earl Warren, Louis Brandeis, Elena Kagan on the U.S. Supreme Court, on the Illinois Supreme Court, Walter Schaefer, Thomas Kilbride. More than 1/3 of all justices of the Supreme Court, both U.S. and Illinois, were never judges before they joined the Supreme Court, just as a baseline fact. So it's actually quite common to follow this path, that you would go straight from being an attorney, practicing as an attorney, to joining the Supreme Court. More than 1/3. And actually, I heard Justice Ruth Bader Ginsburg speak one time about how she would write her own briefs. And she said that she wrote her briefs as if she was writing an opinion. She'd write the opinion and then she'd just change a few words, because what she really wanted judges to do was just copy and paste what she wrote into their own opinions, right? So she viewed herself as writing opinions even while she was practicing as an attorney, writing briefs. That's something that I've tried to do myself when I was writing briefs, including briefs in cases in the Supreme Court of the United States and in courts across the country. But the key thing that I think makes me different is that I have a platform. I'm the only candidate with a platform. Not the only with a good platform. I'm the only candidate with a platform, period. The only one talking about reform, talking about changes, proposing ideas about how we can change policies that will actually improve the system. So if you're interested in systemic reform of the justice system, I suggest that you go to epsteinforsupremecourt.com/issues and check that out. And it's deeply needed. It's deeply needed because we can all be the greatest judges. But if the system is set up in a way that doesn't allow for good outcomes, it doesn't allow our courts to find truth because there's not enough discovery, because we're allowing pseudoscientists onto our witness stands, it doesn't matter. We'll just be writing 10,000 opinions that don't achieve good outcomes. So I'm trying to change that. I'm trying to change the system itself.
Thank you. And just a quick reminder to the audience that if you have a question, please write it on the card and hold it up, and then the students will come and collect it and make sure it's addressed to a particular candidate. The next question is for Justice Reyes. Since judicial candidates who may well appear before those very judges should they be elected. Should we amend the state constitution to require the appointment of judges?
Well, we already do have appointment of judges through the associate judge process, and that, in my view, is the merit selection process that we have in the state of Illinois. I mean, I think some of the finest judges, and some of them on this panel that were associate judges came through that process. You know, I think we already do have a process back where we have there on the bench throughout the state, because all the counties and all the circuits have associate judges. But I think that, you know, with regard to the issue about financing and making out requests for funding, I think we should consider having public funding for candidates who run for judge. I think this, you know, it puts judicial candidates in a very precarious and uncomfortable position to have to raise money. I don't think we should have to be raising money or asking people to donate money. I think we should have public funding. I think that's something that definitely should happen in the state. One of the things I want to point out, and I don't want to correct Justice Neville because he wasn't in the room, but I also did not ask for the party's endorsement. I specifically said that it should be an open primary and that people should decide who sits in the people's court. So that's always been my view. The courtrooms that we sit as judges belong to the people, and the people should make a determination who sits in those courtrooms. Not the politicians, not the party, but the people should make that decision.
Follow-up for Justice Howes. Campaigns cost money. Do you feel discomfort about soliciting attorneys for campaign contributions, some of whom may appear before you?
Well, first of all, we're prohibited by Supreme Court rule from directly soliciting money from attorneys. However, I have invited a number of attorneys to be on my finance committee. I do understand the appearance of conflict, but I've been elected twice before, and I've had a reputation for having integrity and honesty in doing my job, and I think in the past I've demonstrated the ability to be a judge despite the fact that I required donations to my campaign in order to be elected. I make a practice that I'm not going to hear cases where the primary fundraiser is where the chair of my campaign fundraising is a member of the firm. But I think that I can put that aside, as I've demonstrated in my 21 years of being a judge, that I can be fair and honest, and that's the reputation that I have.
Thank you. Question for Justice Cobbs. The U.S. Supreme Court follows a practice in which each individual justice is the sole determiner of his or her own disqualification. Some state Supreme Courts take the same approach, while in at least one state the entire court considers recusal motions. How should the Illinois Supreme Court handle disqualification motions? Should they be decided individually by the challenged justice or by the whole court?
Thank you for the question. I believe that the appropriate response or the appropriate conduct would be to leave that decision to the individual judge. We are charged to abide by the Code of Judicial Conduct, and recusal is included as a part or provision in that code. We are expected to recuse ourselves or to not participate in a case where to do so would create the appearance of impropriety. Every individual judge who is elected in the state of Illinois knows whether or not he or she should participate in a particular case. And I think that the trust and confidence that we repose in those individuals we elect to serve on our high courts can be or should be expected to exercise the appropriate conduct, to recuse themselves in cases or in matters where it might either present or create the appearance of impropriety or in fact be improper for a judge to participate in a particular case. I think that to involve, in this instance, the entire Supreme Court in a decision as to whether or not a particular judge should participate or not participate in a case might lend itself to bogging down or clogging up the system. One of the hallmarks of the Supreme Court is the ability of the 7 justices to be collegial, to act together in a manner in which the entire state law is clear and pronounced with some clarity. And so I think that if we involve the court in deciding for any individual judge whether he or she might or should recuse himself, it might have a chilling effect or perhaps diminish the collegiality that we expect from our Supreme Court justices.
Thank you. And a follow-up question for Justice DeVille. Will you have a recusal policy for campaign contributors? Where should that line be drawn?
Well, it's a very important line to be drawn, and I don't think that there's going to be a policy. I'm going to decide cases as I always have, on a case-by-case basis. The whole point of it, the matter is to avoid the appearance of impropriety. You know, I am an equal justice for all judge. I think the thing that citizens want is to make sure that no person who comes into the court has an advantage over another person. Since I've seen so much unfairness during the time that I was practicing law, and since my goal during my entire career has been to balance the scales of justice, I certainly will not let anything permit me to make a decision that will permit one party to have an advantage over another. I simply feel that I have always made good decisions. Something that the people in this room don't know is I probably recused on more cases during my first year and a half on the Supreme Court than any other justice, because a lot of the cases that I had some contact with on the appellate court were appealed to the Supreme Court. And I took an NP, which is a non-participation on those cases, to avoid the appearance of impropriety.
Justice McBride, judicial diversity is a critical issue, especially for marginalized populations that don't see themselves represented on the bench, but are overrepresented as defendants in the criminal court system. How specifically would you use your power as an Illinois Supreme Court justice to improve diversity in the judiciary?
I would incorporate what many of the judges do now on the Supreme Court. They have a committee designed to screen candidates. I would have a committee as well. I would also, though, make a significant effort to encourage the other justices on the court to join in a policy so that there wouldn't be this preference, or whatever you might call it, that every time there's a vacancy, one of the justices then appoints someone. That's just one of my ideas. But I do believe that a committee should be in place, that the bar associations, all of the bar associations, should be actively involved. We have a number of associations in the Alliance. They are reflective of the different members of the legal community. So I would incorporate their views. I think people should be screened by these many associations. I think the community should be involved, and I think people should be able to comment and help in the selection process. I can assure you that if I were to have the power to appoint, which is rather dramatic and significant, that it would be my business and I would encourage the diversity of all of the appointments. I think we should increase the diversity. I think there are members of different groups. There are people of color. There are members of the LGBTQ community. There are ethnic groups. There are many people that feel underrepresented in the whole process. There are so many candidates running for judges now because they feel left out. So I would promise to have a policy to encourage diversity of men, of women, people of color, people from all ethnic backgrounds, religious members of different organizations. So that would be my policy. It would be open and transparent.
The next question is for Mr. Epstein. Rule 23 allows disposition of cases by summary orders, which are unpublished and have no precedential value under certain conditions. It only allows disposition by written opinion if the decision announces a new rule of law or resolves a split in the appellate districts. Anything that doesn't meet either set of requirements should be handled by a written order. The result is a large number of cases adjudicated by the highest court in Illinois that go unpublished and therefore unnoticed by most of the legal community. Do you support an amendment of the rule?
So I think this is emblematic of one of the ways in which our courts are stuck in the past. Rule 23 was really about dealing with an overwhelming amount of paper. There was kind of an explosion in opinions, and back before we had computers and the internet and places to store all these opinions, it became very difficult to manage all of this. So in order to deal with that, Rule 23 was created. I'm actually sympathetic to it a little bit because I practiced in state court in California where you can find precedent for anything. And so you don't necessarily want someone making precedent all the time if they're not that sure about their opinion. So you know, I think it's a decent way to kind of keep from having a really bizarre corpus of law. But that said, a bizarre corpus of law is sometimes necessary in order for our law to mature, right? And my concern with Rule 23 is that it's burying circuit splits, right? Because if you Rule 23 opinions that are actually emblematic of a split, then it makes it very difficult for the court above, in particular the Supreme Court, to determine whether it should take a case or not. Also, very frustrating to lose a case on a Rule 23 and then appeal, have your PLA denied, and have to worry whether it's because it's just not important enough to the court to take up because it was a non-precedential decision. So, you know, if you're that, I was trying to think of things from the perspective of the client or of the party. You know, really frustrating if you lost in that way, and then you have to wonder whether, even if it's against precedent, the Supreme Court's not going to take up your cause simply because it's not important enough for them from a precedential standpoint. So the short answer is yes, I would agree to an amendment. I think Rule 23 is one of the ways in which our courts are stuck in the past, but it's not totally without merit.
The next question is for Justice Reyes. Justice Reyes, since we're at your alma mater for undergraduate and law school, you get the con law question.
All right.
Justice Reyes, in your view, do you believe that the state and federal constitutions should be evaluated by dictionary terms from back when those constitutional provisions were enacted, or by contemporary usage today?
Which dictionary are you?
The dictionary at the time of the founders of the U.S. or the Illinois Constitution versus contemporary usage today.
Okay, well, one of the problems with that is the Constitution actually has evolved throughout the centuries. I mean, we were an agricultural state when the first Constitution was written. It was predominantly focused on agricultural issues. You know, Chicago was maybe at one hot town at the time. You know, and as we evolved as a state and we become more commercialized, I think that you know the Constitution has changed. And you know, recent Constitution change in the 70s, you know, our Bill of Rights was expanded. So, and that's why I was asking about the dictionary, because it depends on, you know, what dictionary you're using. It was the Founding Almanac back in 1882 when the first Constitution was established. The definition is going to be different. But I think we're fortunate in Illinois to have a Constitution that is constantly evolving and growing with its community, because our laws are really kind of based on society, whatever society's view is. You know, our laws should proceed along those same lines. I don't know if I answered the question.
A question for Justice House. Please describe your view on how you would plan to exercise your supervisory administrative authority over the lower courts.
Well, one of the most important aspects of the complaints that I get about the judicial system is that justice takes too long. I think I have demonstrated on the appellate court a willingness to speed up the judicial process. As I stated earlier, I have led the court in the last 4 years with zero backlog on my docket, and that includes the individuals who sat on the Supreme Court who are sitting up here today. And I passed a rule which says that anybody who had a case over 6 months old who had not written a written decision has to write a report to the committee explaining why they hadn't done the work. As a consequence of that, the number of cases that were over 6 months old dropped precipitously. It was almost zero. I will bring that desire to speed up the judicial system to the whole court system. And I can do that from the Supreme Court. That would be the way I would address, main reason, the way I would address the system.
Thank you. And the next question is a follow-up for Justice Cobbs. Justice Cobbs, what specific initiatives would you pursue in improving the functioning of the courts at the circuit level?
Thank you. I have had the privilege of serving as the director of the Illinois courts for 9.5 years. So I participated in a good deal of administrative change, specifically introducing e-filing and e-access to records, digital recording in the courtrooms, performance and accountability strategies for the Illinois courts, increasing the judicial education training for judges to 30 hours every 2 years, making it mandatory, enhancing the mentoring program, proposing amendments to Rule 56, which gives circuit court judges, chief circuit judges, more administrative authority over their judges. That's in the past. What I would do in the future is perhaps expand access to justice programs. I would also introduce performance measures for our trial judges. Getting back first to the access to justice. We have a large population of self-represented litigants who come into our courtrooms daily. And when I was on the circuit court, I certainly sat in 2 high-volume courtrooms, the eviction courtroom and in debt collection courtroom. Many of the litigants who came in were unrepresented by attorneys. Every law school annually would submit to the director of the Illinois courts a certification seeking to have law students licensed to engage in the limited practice of law. I would authorize that practice by issuing certification, a 711 certification. I would, if elected to the Supreme Court, amend Rule 711 to require that those 711 law students spend some time helping self-represented litigants who come into our courtrooms to be able to maneuver around the courtroom and in processes. I would also introduce performance measures for our judges in every court level, at the trial court level and at the appellate court level. The National Center for State Courts has developed a process, a program whereby we can measure performance of our judges in every court setting. Some of that is being done in the law division in the circuit court. On the Supreme Court, I would introduce and mandate that the court systems engage in performance measurement in every level.
And a follow-up question for Justice Neville. Justice Neville, in the view of many, Cook County was unacceptably slow in instituting electronic filing or e-filing. As a Supreme Court Justice in the 1st District, what specific steps would you propose to facilitate the digitalization of the courts?
Well, let me say this. Once I joined the Illinois Supreme Court, I discovered that there was a problem with e-filing. The problem is brought on by the fact that there are 102 counties in the state of Illinois. All those counties act independently of each other. They all have different computer systems. Therefore, when the court brought in a company to try to establish e-filing, it became very difficult to merge all those different computer systems into one. As much as I'd like for there to be one court system. There would have to be some substantial changes in order to bring that into existence. It is a problem because of the individual county system. I am facing that problem right now because I am the liaison to the Pretrial Practices Commission, and we are trying to resolve the question of whether or not we're going to get rid of cash bonds. That is a major problem. Counties in the northern part of the state are able to function and manage their jails without receiving the 10% that is received when people post bail. Counties downstate are unable to continue to function with their jails if we take that money away. It's simply a big state with 102 counties. There needs to be a way to kind of bring them all together. I think it's a legislative solution. It's not something that the Supreme Court can do, however.
Justice McBride, one of the roles of the Supreme Court is oversight of the circuit courts and data collection. But the data collected and released by the Supreme Court and the Administrative Office of Illinois Courts is limited and incomplete, in part because the judicial branch is not subject to the Freedom of Information Act. What would you do as a Supreme Court justice to improve data collection, transparency, and oversight of the circuit courts?
Well, hopefully I would use technology to implement the better oversight of the circuit courts.
Mr. Epstein, do you support the televised broadcast of proceedings at the trial level? Why or why not? And if so, what standards should be in place to regulate such televised broadcasts?
Yeah, in general, I do. I think one of the issues with our courts is that they've kind of turned into resolution machines, trying to get cases through as fast and efficiently as possible. But our courts also have to be information factories. They're places where we learn about our own society, areas where we're failing in some cases, right? Areas where we're experiencing serial police misconduct or bad forensics. Those are opportunities to learn about things that are happening in our society to people who might not have a voice, including people I represented. So we need to view our courts as an information factory, and I think televising proceedings is a way that we can improve that, because the public record is a public good. It's really valuable, and courts have a major role in that. But there are some limitations, right? So in cases where might involve juveniles, you might want to limit that. You might want to limit the ability of cameras to roll during sidebars. You might want to make it so that the cameras can't, or recorders don't catch client-attorney conversations, right? So there are a number of things that where we might not want the cameras to be rolling or the recorders to be rolling. But in general, I think the default should be, yes, let's allow the public into our public courtrooms. Let's make it easier for them to see what's going on. Let's build our public record, because it's really, really valuable.
And we're still collecting questions if there are questions from audience members. Our next question, next moderator question is for Justice Reyes. A recently enacted Cook County ordinance banned pretrial detention of children under the age of 12. Last year, a circuit judge found that the ordinance was unenforceable because Illinois state law allows the pretrial detention of 10 and 11-year-olds, and a divided panel of appellate court judges agreed. And the public defender's petition for leave to appeal to the Supreme Court was denied. How would you balance the question of the city ordinance and home rule with the question of whether the pretrial detention of preteens should occur? And by way of background, the United States is one of only 2 United Nations member nations who did not ratify the Convention on the Rights of the Child, which provides that children under 12 should not be involved in criminal justice systems.
How would I balance the home rule versus the...
Exactly, yes. How would you balance the question of the city ordinance and home rule with the question of whether the pretrial detention of preteens should occur?
Okay. Well, I mean, I think you have to look at the home rule statute and whether the municipality is actually a home rule. I mean, there's certain limitations in terms of what you can do as a municipality with regard to home rule. But I mean, the issue it pertains to protecting our children. I think that's first and foremost. We have to make sure that they are protected and that they're detained. Why are they detained? One of the problems that we have in our system of justice right now is that we have places like juvenile detention centers and Cook County Jail that are serving as mental health institutions. So we definitely have to make sure that if there's a question about mental health, if that issue is addressed, why is the child being detained? It might be for mental health reasons, it might be for physical health reasons. But at the same time, I think we have a big problem with regards to mental health that needs to be addressed. And that's first and foremost in terms of taking care of our children, and then also making sure that these people that have mental health issues are assessed, diagnosed, and treated.
The next question is for Justice Howes. Justice Howes, do you believe that the Supreme Court should be proactive in sponsoring initiatives to expand the availability of legal services to those who have a difficult time affording them? And more specifically, do you support amending certain procedural rules to allow non-lawyers to perform some functions presently reserved exclusively to lawyers, such as assistance in residential real estate closings or simple wills?
Studies have shown that in the 102 counties in Cook County, when you look at the civil cases, over half the cases involve a self-represented litigant. I think that we can do things to make it easier for self-represented litigants, such as revising the forms that we use, that we provide to allow access to the court system. I think we can print the forms in languages other than English to allow people who don't speak English to get access to the courts. I also believe that with regard to representation, I believe that we should allow partial representation, that individuals who are self-represented can have a lawyer step in at a critical point, perhaps in the beginning, and be able to step back out of the case in order to give representation to self-represented litigants in critical phases of their litigation. With regard to non-lawyers, I think it's a dangerous thing to allow a non-lawyer to represent a party in the case. And why is that? You have a person who's not trained in the law, maybe, perhaps, doing a misstep, which is going to critically hurt another individual. I think I would be very cautious about letting a non-lawyer do it. If that were to take place, it'd have to be a trained person in limited fields, such as perhaps forcible entry detainer. But I think that we have to address the self-represented litigant because it is a growing issue, not only in Cook County, but across the nation in civil cases.
Justice Cobbs. Debt loads which law students are taking on have grown exponentially over the years, and many commentators have expressed concern about how these financial burdens are affecting the profession. What are your thoughts or ideas on how this problem can be mitigated?
Well, we probably could have substantial dialogue with the several deans across the state and across the country, because those several deans certainly have some knowledge with respect to what's going on in the communities and how recruitment efforts might impact even the admissions of law students into the law schools. You know, the Supreme Court has taken some steps to partner with law schools in matters of civility and professionalism. And those law schools have been receptive to having dialogue with the Supreme Court. So I don't think the court has ever been insensitive to some of the burdens that are borne by law students or individuals who wish to enter into the law profession. The court has always been welcoming of those individuals. I think that certainly legislators could have a role in determining some relief for law students who might incur debt. I think also, though, that there could be and should be some dialogue between the members of the Supreme Court and the various deans of the law school with respect to the debt burden incurred by law students who are seeking to achieve that law degree.
Thank you. We're now going to transition in the 10 minutes remaining for questions to the candidates by our student representatives from UIC John Marshall and from the audience. Again, our student representatives have been collecting your questions. Now is your last chance if you want to send one up here. We'll then revert to the candidates for 2 minutes each for closing statements. The opening question is for Justice Mcbride. What is the most important thing to change, in your opinion, about the Illinois Supreme Court?
Well, I'm not on the Supreme Court, so I'm not sure that I can really discuss how I would improve it. I would say that I'm a hard worker. I like to dig into things. I think that I would love to be on the Supreme Court. I think the Supreme Court could take more cases. I would encourage that. I think the Supreme Court should actively make certain that the court system itself is functioning and that every courtroom in the entire state and every judge is working to his or her capacity. Those are things that I think need to be improved. I think the cases that are heard in our courts probably take too long. It's not of crisis proportions, but I think there's more self-represented litigants because it's very expensive to be involved in litigation, but it's also time-consuming. So that is something I would like to improve upon. I really think that we need to move cases along. I've been in 5 divisions where we had enormous dockets. We don't really have a significant problem on the appellate court with our judges. Actually, our dockets are fairly low compared to years past. But those are the things that I would encourage. I'd like to see more cases. I think the chief business of the court is deciding cases. And actually, they already have quite an enormous task by deciding about 1,500 PLAs a year, whether or not to take them. That's about 7 cases a week. That's a lot of reading. I love reading. And I would do my own reading. So I think that taking more cases and making sure our court systems are fully staffed and working effectively are things that I would work on.
Follow-up question for Justice Cobbs. What are the principal criteria you would use in deciding whether to grant a petition for leave to appeal?
So I believe that the current criteria that the court uses to determine acceptance or denial are appropriate. Whether there is a conflict among the districts, whether there is a lack of clarity in the law, whether there is no law that would help a litigant or lawyers who are practicing decide a matter. I also think that sometimes there can be substantial prejudice in certain cases. And having served as a Supreme Court judicial law clerk, I know that that has not always been the criteria. It has been on some occasions. There was the case People versus Blue, where the abuses and the prejudice in that case was so egregious that the court did take it. I think that the court could take a closer look to make certain that in those cases that even come close to a People versus Blue should be a case that the court takes. So I think certainly the several criteria that exist currently should continue to inform the court, but in those cases where it is clearly erroneous at the lower court level, or where the abuse is clearly, or the prejudice is clearly clear to the court, they should then grant that PLA.
Justice Reyes, to revert to you, what is the most important thing in your view to change about the Illinois Supreme Court?
Well, I've been on the record from the very beginning that I see 3 issues. One is lack of transparency with regard to appointments, lack of access to justice, and lack of diversity. I think the Supreme Court could take a leadership role in those areas, in particular with regards to lack of justice, as I mentioned earlier, about mental health. In this country, 2.2 million people are incarcerated throughout this country. 750,000 of those individuals are in jails. Half of those are waiting to be processed, to go before a judge. And Illinois, unfortunately, is the #1 leader in terms of offending those statistics. So we need to take care of the people that are in our jails, get them assessed, get them diagnosed, give them an opportunity to be heard, go before a judge. It's unfortunate that Cook County Jail is the largest mental health institution in the entire state. It's a jail. It's not a mental health institution. So we need to take care of those people. We need to be passionate about those individuals that are there, and they make sure that they have their day in court. So I think that's number one with regards to something that I would take a leadership role in establishing a commission made up of psychiatrists, psychologists, nurses, retired judges, lawyers, and have them assess how do we develop this, how do we get the funding to take care of this, because there is a funding issue. But the court has taken leadership roles in various other aspects of the law. For example, with diversity. As I mentioned before, I founded the Diversity Scholarship Foundation before it was popular to talk about diversity. And, we struggled to push the issue. The Supreme Court a couple of years ago, under the guidance of Chief Justice Carmine, came out with a rule that told everybody you got to include diversity and inclusion in your seminars. Now everybody's jumping on board. Now everybody, all the bar associations are having diversity and inclusion seminars. So that's just an example of how when the Supreme Court takes the leadership role, things can get done.
And the same question for you, Justice House. What is the most important thing to change about the Illinois Supreme Court?
I agree that one of the things that has to change is the judicial appointment process. And the reason I wanted to change it, I want to open up the process so that whenever a judicial vacancy is open, it will be advertised to all the bar associations so that every lawyer who has a desire to be a judge can know that there's a vacancy open and they can apply for it. Right now, it's like a closed system. If you don't know anybody, you can't get appointed to be a judge. I want to open that system up so that lawyers who have ability can apply, and I would then use a committee to winnow through that. But no one would be appointed judge unless they completed the application and fulfilled the requirements. I would also advocate a rewrite of the rules. One of the main, we talked about this earlier today, the number of self-represented litigants. When you look at our Supreme Court rules, it's legalese. It's difficult for a non-lawyer to really negotiate. I think we can rewrite the rules in plain English so that a layman, a person who has graduated from high school, can understand those rules and still be just as efficient and just as precise. But I think the language can be changed so you don't have to be, a John Marshall law graduate to understand the Supreme Court rules. I think that would make things better.
Thank you. Justice Neville, this question is for you. Under the limited lockstep approach, Illinois courts may apply an independent analysis when a specific criterion, such as unique state history or state experience, justifies departure from federal precedent. What are your thoughts about the limited lockstep doctrine, and how limited do you think it should be?
Well, the limited lockstep doctrine is a doctrine that says when the U.S. Supreme Court has a constitutional provision that mirrors or is very much like a state constitutional provision, and the U.S. Supreme Court has rendered a decision on that particular issue, the state Supreme Court is supposed to follow it. Of course, I have been a person who has always been concerned when I am confined by my decisions. But that is the law in the state of Illinois. While I am troubled by some things, there's some precedent that says if the two constitutional provisions are the same, that is the state constitutional provision and the federal constitution provision, and the federal Supreme Court has weighed in on it, we are supposed to follow it. Of course, the state constitution in certain areas is a little broader, and sometimes the state court has a little discretion. But the lockstep doctrine is one that troubles me, but since I am bound to follow precedent, and I believe in the principle of stare decisis, and I think that the game should be played by one set of rules, I will follow those precedents that have been set out by the Illinois Supreme Court.
And the last audience question is for Mr. Epstein, and then we'll turn to closing statements. Mr. Epstein, how will you affect change as one person among seven where there is a deeply entrenched system?
Yeah, great question. So for the Supreme Court to do basically anything, it needs 4 votes. The Supreme Court doesn't report out its votes, so we don't know how far off we are. We don't know if we might be 1 vote away on some of this stuff already. We might be 4 votes away, but we don't know. And some it's probably 1, and some it's probably 4. But ultimately, this is what I believe. There's a poet who said it better than I can. There's a guy named G.K. Chesterton. He said, "The terrible thing about all legal officials, all lawyers, all police, all judges, all detectives, is not that they're wicked. Many of them are good. It's not that they're stupid. Several of them are quite intelligent. It's simply that they've gotten used to it. They no longer see the prisoner in the dock. They just see the usual man in the usual place." I think that's the issue. I don't think that the people on the court are wicked. I don't think they're unintelligent. On the contrary, I think they're good and I think they're smart. But I think that they're very, very used to the way things are. And that's a good thing, because I don't know how to make wicked people good. I don't know how to make unintelligent people smart. But I do know how to make people not used to it. And that's what I plan to do. Persuade, make you not used to it, make you feel the pain of people who are going through it, and argue for reformation.
For the last portion of tonight's forum, we're going to hear from each candidate in a 2-minute closing statement. And this time we'll proceed from my near left to my far left. Justice Cobbs.
So before they start that clock, www.justicecobbs.org, because it's never going to happen in 2 minutes. So my punch number is 164, which you may not be aware of. I am the only candidate who has served at the trial court level, the appellate court level, and have worked closely with the Supreme Court justices. The work of the Supreme Court is defined by the Illinois Constitution. It is to decide cases to which the court takes on petition for leave to appeal, as well as those that are mandated by the Constitution, and to administer and supervise the court system. I have done the work that is dictated by the Constitution. I've served as a circuit court judge, in eviction court, and in civil juries. I have served as a Supreme Court law clerk, deciding with Justice Freeman, collaborating with him on cases that have come up on appeal. I have overseen and administered the Illinois court system. I serve on several Supreme Court committees. I am a member of the Illinois Supreme Court Rules Committee. I serve on the Supreme Court's Judicial College Board. I have previously served on IPI Civil. I wrote the charge for the Evidence Committee. I wrote the Rules of Procedure for the Illinois Courts Commission. I am active in my community. I serve on the South Suburban PADS Board, Services and Resources to the Homeless Population. I'm also a member of the Board for Lawyers Lend a Hand, an organization that provides services and resources for at-risk children. And on every Tuesday evening for 3.5 years, I have tutored a child from the Inglewood Montessori School. My experience and qualifications are diverse. They are broad. They follow a different trajectory. They are nonetheless deep and solid. And so I am seeking support from the voters in Cook County to do something different in Cook County. Elect someone who has the legal competence and the administrative experience to serve as a justice on the Illinois Supreme Court. Thank you again for having me and for allowing me to offer my comments this evening.
Justice Neville.
Good evening, and thank you once again. I am the only person sitting up here who is on the Illinois Supreme Court. I'm the most experienced candidate up here. I have 45 years of legal and judicial experience. I am the only candidate who has been found highly qualified by 5 bar associations. I am the only candidate who has a body of work which is unmatched. How do we know it? Because over 180 articles have been written by the Law Bulletin and other publications about my decisions. But ladies and gentlemen, that's not the real issue that's before us today. The New York Times reports that the nation's state courts face a crisis of legitimacy. That crisis of legitimacy is brought on because white courts don't reflect society. 40% of the people in the United States are people of color. Over 60% of the people in the city of Chicago are people of color. But there are 23 Supreme Courts that don't have a person of color on those courts, and there are 13 states that have never had a person of color. Cook County voters must decide if the Supreme Court will avoid the legitimate crisis by retaining a person of color on the Illinois Supreme Court, Or will the Illinois Supreme Court have to address the legitimacy crisis if voters elect a justice and the Supreme Court becomes an all-white court? That is the question that is presented to us. We must address it.
Mr. Epstein.
You know, sometimes an issue is more important than an individual, and so rather than talk about myself, I heard something that's really kind of outrageous, which is that the reason that we haven't ended cash bail is because jails in our state wouldn't be able to fund themselves without it. That's unconscionable to me. If we didn't take 10% of their D-bond, some of our jails might not be able to fund themselves. That's not what bond is about. Bond is supposed to be about public safety and making sure people come back to court. Neither of those things have anything to do with taking 10% of a D-bond. We need to end cash bail. It's one of the greatest contributors to mass incarceration. If you care about mass incarceration, we can end cash bail. The fact that the progress is being held up by funding for jails is so disturbing and so separated from the human experience that my heart is racing a little bit right now. These are people, presumed innocent, many of whom might be deemed safe to return to the community, but who are lingering in jail sometimes for years because our jails can't fund themselves without it. We'll find a way. I promise you we'll find a way. But it can't be by keeping cash bail going. That's outrageous. That's all I have to say.
Justice Reyes.
Thank you. Again, I wanted to thank the moderators, our sponsors, our hosts, and all of you in attendance this evening for being here and allowing us an opportunity to express our views and to discuss some of the questions that are pressing for everybody here. And I agree with Mr. Epstein. We should reform the cash bail system that we currently have. He's almost as progressive as I am. And, you know, I bring diversity of background, diversity of experience, and diversity of perspective. I have also been found highly qualified by 5 of the bar associations in Cook County to run for the Illinois Supreme Court. And there's another aspect that I bring, is accountability. You know, I don't just come around our communities and ask for your vote when it's election time. I'm there all the time. And I'm always there supporting our children, our disenfranchised, our marginalized, the people that live in economically disadvantaged neighborhoods. And I do it because I believe that that's what we do as public servants. We just don't write decisions on an ivory tower and then only come around and ask for your support on election time. I do it all the time because that's who I am. I'm a public servant. If you want a public servant on the Illinois Supreme Court, then I'm the candidate. You know, for example, aside from legal matters, I am very active in the Lawyers Assistance Program, helping people with substance issues, with depression, with drug problems. I work with children out on the west side, an organization called BUILD. We work with them to develop their confidence to become public speakers and to help them to get into colleges, and I'm very proud of that. I also work with A Safe Haven, an organization that works with battered women and veterans, because I believe that we have to help each other out. If we don't help each other out, no one else is going to help us. So that's who I am. I'm going to ask you for your support. And you know, keep one thing in mind. The justice who retired from the Supreme Court was Justice Charles Freeman, a dear friend of mine, and a fellow alum from this school. So let's keep the seat at John Marshall. I would ask you, if you want to get it done, vote for 161.
Justice House.
Again, I want to thank the sponsors of this program for giving us the opportunity. I believe the most critical job that the court does is to make its decision. And I think the decisions that the Supreme Court makes are based basically on the perception, the perspective that each judge has. Because those cases that come before the Supreme Court are narrow. And sometimes the decision depends on how the judge sees things. I think my background is growing up in the Jim Crow laws, under Jim Crow laws, attending segregated schools, provides a unique perspective that is not present on the Supreme Court. I think that perspective makes our court decisions richer, and I think it can improve the court. I also want to do a pilot program to speed up the decisions making in our courts. I describe how I help speed up the disposition of cases on the appellate court. I think I want to do a committee to study ways to improve the administration of justice so we can eliminate the backlogs. I read about a case last week where a gentleman was arrested 7 years ago, and he's just not going to court. Of course, there's sometimes reasons for those delays, for some delays, but 7 years I think is entirely too much, and I think we can study ways to improve the justice system. But again, I have 43 years of experience as a lawyer and a judge. I've had complex cases. I believe I'm the only judge who's ever argued a case before the Supreme Court. I believe I'm the most qualified. I've received highly qualified from several bar associations, well qualified from another, and I believe that if you pick me, you will have someone who's willing to change things, shake up the rules, change the Supreme Court rules so that people can understand it. Eliminate the buddy-buddy system in terms of appointment of judges. I will open up the process, and you will see a change with me. So I ask you to remember, on March 17th, House is in the house. Punch 168 and don't be late.
Justice McBride.
I'm not going to spend the next 2 minutes talking about myself. You can find anything you want to know about me on my website. What I want to do is talk to the law students that are here and tell you that you are in a great place. I have never regretted that I went to law school, became a lawyer, became a judge, became an appellate court judge. There is so much ahead for you. And I know that people in this room are going to really care and study before they make a decision about who they're going to vote for. But I want to tell all of you that pursue any dream you have. You're going to find different paths along your way as a lawyer. You're going to become a lawyer. It's a great profession. It's honorable. We want everyone to keep it that way. And being a judge is a great, great honor. I am so lucky and fortunate that I have become a judge. But I also want to tell you this. Don't listen when you hear somebody say, you can't become a judge unless you know someone. I am the absolute proof of the inaccuracy of that statement. You need to pursue your dreams, whatever you want to become. I was always taught that I could do anything, I could become anything, and I did what I wanted to do. My dreams have been accomplished. So never give up on your dreams. Don't let people tell you you can't do something, you can't become something. You don't need that in your life. Anything you want to accomplish in this world can be done. And so I urge all of you to become great lawyers, and if you want to become judges, go for it, because you can do it, and you can do it without knowing someone.
Before we adjourn, and I hope you'll all join us for the reception in the Boilerplate Cafe, that's the student space on the lobby level. On behalf of the Chicago Lawyers Chapter of the American Constitution Society and Injustice Watch, thank you all so much for coming. One of our shared missions is outreach and civic engagement. And I think we can all agree tonight, folks, this is a really important job. So please, spread the word. Urge your friends and colleagues and family members to educate themselves about how important this office is. And come March 1st, check out the Injustice Watch Cook County Judicial Voters Guide, because this matters. Thank you all for coming. See you downstairs.